Structuring the deal, loans, leases, operational risk, and large aircraft rules. Hello again, this is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Now let's turn to the second major issue, how the finance structure must fit the way the aircraft will actually be used. This is where otherwise sophisticated clients can get in trouble. They negotiate rate, amortization, reserves, guarantees, and prepayment language very carefully. Then they treat the operational structure as an afterthought. For large turbine aircraft, that's backwards. The operational structure is often what determines whether the financing remains stable or it blows up. Consider the difference a straightforward secured loan, or the difference between a straightforward secured loan and a leasing structure. A loan may be documented as a note, security agreement, guarantee package, and FAA recorded conveyance documents. A lease may shift tax, accounting, liability, and residual value assumptions. But under the FAA regulations, neither label answers the most critical question: who has operational control? FAA Advisory Circular 91-37B is indispensable here. The FAA explains that truth-in-leasing requirements apply by regulation to aircraft weighing more than 12,500 pounds. And the agency emphasizes that leases and conditional buyers must understand operational control before entering the arrangement. In other words, the rules exist because the FAA expects confusion precisely where money and operational authority intersect. Under 14 C.F.R. 9123, parties to a lease or contract of conditional sale involving a U.S. registered large civil aircraft must use a written agreement containing the required truth-in-leasing clause. Identify the maintenance and inspection status for the previous 12 months. Identify the person responsible for operational control, and provide advance notice to the FAA before the first flight under the arrangement. This is not clerical trivia. It is the registration or the regulation telling you where the legal pressure points are. Part 91 Subpart F matters as well. Section 91501 applies additional rules to large turbine, U.S. registry and turbojet-powered multi-engine civil airplanes of U.S. registry. This is why large turbine aircraft structures often involve time-sharing agreements, interchange agreements, joint ownership agreements, charter management, or pure dry leases that must be handled with precision. A real-world example, it drives this point home. The question often arises, why? We will just put the aircraft in an LLC, have the management company schedule it, and dry lease it when needed. That assumption or that arrangement can describe a lawful structure. It can also describe an unlawful one. The answer depends on who selects and controls crew, who has authority to initiate or cancel the flight, who bears maintenance responsibility, as well as who can say no to the principal, and whether aircraft and crew are really being packaged together. That is why large aircraft finance counsel must care about the same questions that enforcement counsel cares about. If the lessor, management company, and pilot source operate as a single commercial machine, while the paperwork says the lessee is in control, the documents, they're not reducing risk. They're just storing it. The North Carolina dry lease case announced by the Department of Justice in March 2024 is a good cautionary example. The government alleged that the defendants operated more than 150 paid passenger flights through sham dry leases that were in substance wet leases, and the matter was resolved with a $700,000 civil penalty. Whether one calls that a leasing problem, an operational problem, or an enforcement problem, it all begins as a structuring failure. Large turbine aircraft also raise an asset planning issue that clients underestimate. Engines are often their own legal and financial universe. FAA and Cape Town rules separately recognize certain engines as recordable collateral. Market participants therefore pay close attention to engine serial numbers, maintenance program enrollment, reserve exposure, and transferability. On many older jets, the engines are not accessories to the deal. They are the deal. Here's something to remember, something to take away. The financing documents should not tell a different story than the flight department. A second example for emphasis here helps. Suppose a borrower finances a super mid-sized jet through an owner trust, grants a security interest to the lender, places the aircraft with a management company, and expects occasional reimbursement under Part 91, Subpart F. On paper, each piece may be familiar, but if the trust documents, management agreement, lease language, insurance provisions, scheduling practice, and actual trip approvals do not align, the structure becomes more fragile exactly where the lender expects certainty. The right approach is disciplined alignment. The ownership vehicle, financing documents, recordation package, registry filings, lease documents, insurance endorsements, operational manuals, and actual conduct all need to tell the same story. Because in this part of aviation law, structure is not what the binder says. Structure is what the aircraft actually does. The bottom line is that large turbine aircraft finance is never purely financial. It is transactional, regulatory, and operational all at once. Here's something to take away from this and remember. The best aircraft finance structure is not merely bankable, it is operable. Thank you for your interest in this topic. This information is provided for informational purposes only, and it should not be construed as legal advice. Please direct questions, and they're certainly welcome, to admin@aviationlegalcounsel.com. We look forward to helping you navigate these issues with precision.